that circuit bench matter before your lordship?
Yes, we'll list it maybe next week.
Grateful. Grateful.
Not one urgent appeal without the certified copy.
On Monday. Don't mention today. Yes, call the list.
Lord, very,
On
very
Monday.
urgent.
You mentioned
No
item
mention
number
today. Yes,
1,
please
2,
call the
3.
list.
My lord had passed the order yesterday.
No. It seems that all earlier orders were transcribed under wrong number. So all these orders are required to be corrected. Numbers.
No, my lord, order is already on the server now.
That order is perfect. All previous orders has to be corrected.
Oh, previous.
Previous orders.
তোমরা লিস্ট করছো কেউ দেখছো না অদ্ভুত yes.
New applications, item number 4.
Take down. The appellant is not
School.
Yes. No affidavit of service has been filed showing
Lordship, please to adjourn this.
this is what, yes, for the list. হবে? না, এটা তো কোনো কথা হলো না। কি করেছিল না? করেছিল না? কেন ডায়েরি করা ছিল না স্যার?
My lord, in item number 4,
I have dismissed
I-
the default. We cannot. Yes, next, call the next matter.
my lord,
Therefore,
I was for the state. Unfortunately, the affidavit of service is still not with me. I tried to contact the AOR.
we have dismissed the.
My lord.
default. সাপ্লি করলে বুঝবে কি করে তারা? বাড়ি থেকে বুটটা নিয়ে আসবে?
I'm the
My lord, I am for the respondent. Respondent number 456. I am led by Mr. Sandeep
Well,
Kumar.
But I am online due to my personal difficulties. But the affidavits have been, I have affirmed the affidavit, it could not be served. But may I serve the affidavit and takes up the matter next week, Lord, next Thursday?
Lordship, I am the petitioner, my lord, appellant petitioner. My lord,
I am for the school authority. The respondent number 4, 5, and 6.
I am for the school authority, but there is for 4, 5, and 6.
my lord, let the file the affidavit in opposition and at the same time serve the copy.
May I file my affidavit in opposition, Lord?
May I file it?
And kindly takes up this matter next Thursday, Lord.
Should affirm within time.
Affirm.
Yes, affirmed within, it could not be served, Lord. It's my fault, Lord. It is affirmed within time.
The affidavit in opposition affirmed in time on behalf of the respondent numbers 4, 5, and 6 is taken on record. A copy of the said affidavit shall be served.
Here and now.
Copy of the
Now.
affidavit in opposition has been served in court today upon the learned counsel representing the appellant. Petitioner will stop.
Lordship, kindly grant me 10 days time at
Time
least
to file reply.
to file the reply.
The time to file reply, reply if any shall be filed within a fortnight from date.
I'm grateful.
The matter stands adjourned for 3 weeks.
I'm grateful.
Deeply obliged. I'm grateful.
I'll skip you.
মামলা নিষ্পত্তি হচ্ছে মিনিট 25টা বা 30টা।
flash, my lord.
Take also. Take down. The appellant is not represented.
I'm appealing for the appellant, my lord.
Which one?
157, my lord.
157.
Yes.
This is the matter. Lordship, kindly have a look to the order under appeal of 9th of February 2023. ছেড়ে দেবো না ছোট করে
Yes, this matter this matter was simply adjourned. This matter was simply adjourned.
Yes,
So how you are agreed by this order?
but my lord, the
It was a matter of inquiry. Nothing is decided. There is nothing decided. How you are agreed? Take down. We have read the impugned order. We do not find
the
any reason.
observation, my lord, may I? This observation My lord,
You have said that by the order under appeal, the recommendation of the applicant was cancelled. Where do you find it?
my lord, because my lord,
You are
the-
appearing.
Appearing with the commission, madam.
Yes.
my lord, I direct the commission to
Hmm.
take up with one short affidavit disclosing the factual situation of the hard disk from the CBI, verifying the answer string.
So
there.
nothing is decided,
No, nothing was decided.
then
Pursuant to this order, my lord, the recommendation letter was cancelled. My recommendation
that's a
letter.
different issue. That then you challenge that. Then that you challenge in this writ petition. Who are you?
But I was not the party in this writ petition. my
Yes, so
lord.
so it may give you a fresh cause of action to challenge it.
May I
Yes.
kindly adjourn it today, my lord? I am not wholly prepared today, but kindly adjourn.
Question is this order has directed the commission to carry out certain things. As a consequence of this, commission has taken a steps. You have a right to challenge it.
Now the commission will say pursuant to the
Whatever
order.
is said, you challenge it. You challenge it if that by a writ, take down. The application for leave to prefer. Yes.
158.
158, my lord, I am for the writ petitioner respondent, my lord. This is a matter, my lord. The issue is pending before the Supreme Court, my lord.
Which
There
for the appellant?
I am for the appellant, man.
Which
My
issue
lord,
is
the
pending?
issue relates to their appointments by an order of this court, my lord. It's School Service Commission published a list of candidates whose
So
memberships
matter
are.
is pending for the Supreme Court.
Yes, my lord. It may be they have also probably they are before the Supreme Court.
Supreme Court,
also.
yes.
They have also before the Supreme Court.
The last date of Supreme
The
Court
learned
28.
counsel for the learned counsel for the parties submit
Next, 159.
But I am for the appellate.
I'm for the statement, my lord.
My-
This is my
lord,
reply
I am
to their
for the
opposition used by the state respondents.
Yeah, আমাদের ক্ষেত্রে
In this matter, what happens, your lotus?
Who is appearing for the Director of Public Instruction?
Not my learning.
You are appearing.
Yes. Kindly see the page 612.
হ্যাঁ বলেছি একটা কপি দিন একটা কপি লাগাতে হবে
Now, where is the affidavit of Director of Public Instruction?
Yes, my lord, I have just now.
Right over there.
Right, respondent number 2.
No, respondent number 2, yes.
দাদা আপনি কি দিলেন আমাকে কপি দিন কপি দিয়েছি কোথায় কপি দিন
We have asked you to file an affidavit dealing with paragraph 6.
Yes.
So why you have filed an affidavit like
Page 6,
Yes, my lord,
paragraph 12, my.
I have already stated, my learned friend, that
Yes, very well.
exception.
রিপ্লাই দিল সিনিয়র দাদা আমি দিকে দেন
So,
That is wrongly stated, Shankar Kundra, I have, in my reply, I have stated, my lord, it should be, the name is, my lord, otherwise. But they have given, my lord, if your lordship kindly come to,
no,
they
no,
are-
when
Pe-
the
died petitioner father, my lord, in 2012, 2nd February 2012. That is before December 2030. And petitioner applied, my lord, in the month of November 2012.
My lord,
Your lordship kindly come to, your lordship,
if they have applied
10
at that point of time,
yes.
then it has to be considered on the basis of the policy existing.
My lord, I'm coming, my lord.
your
Lordship,
lordship
before
kindly,
that, kindly see the page 4, paragraph 10. The petitioner stated that one Shankar Kundu who was appointed on compassionate ground. I have paragraph 10, page 4. I have mentioned, my lord,
There is no employee on the name of Shankar Kundu. Very well.
Shankar Kundu. And as per your lordship's direction, paragraph 12, page 6,
Yes, if these persons,
3 person appointed on the ground to compassionate.
so why his case
My
cannot
lord,
be
I am
considered?
coming, my lord. On this issue, my lord, point is at the time of the sending the papers to the authority, whether at that point of time is that earlier notification has the existence or not. Number one question.
This case has to be considered when he.
No, my lord, kindly see the I have annexed as per your lordship's direction 251
Yes,
notification. Kindly see
yes.
as per your
no,
lordship's
lordship
direction.
directed only regarding, my lord,
No, no, direction.
Yes.
Direction. The governor is pleased hereby to make the following scheme relating to appointment on compassionate ground in supersession of all previous orders in this respect. Next, this scheme may be called the West Bengal Scheme for Compassionate Appointment 2013. This will come into force with effect such and such. Application. This shall apply to the defendant family member of a government employee.
No, this
Yes.
will, this will apply provided this scheme will apply to all the employees who have died after the scheme has come into operation.
Yes.
This scheme shall apply to the members. Now, if you suppose we take it that this scheme is there, so this scheme will not be applicable to him.
Applicable to the aided college or university.
So it
This is not applicable.
So it is not an aided college or university.
Yes. This notification 251 as per your lordships, I have annexed. This is kindly see paragraph application. This shall apply to a defendant family member of a government employee only. Aided university or aided college, not the government
No,
college.
that
or
is what
uni-
he said.
Yes.
That's what he said. But when he died,
Yes,
that time, this earlier circular was applicable.
Yes, my lord.
yes, my lord.
Yes.
On this issue,
Yes.
very recent, the Honorable Apex Court, I have handed over to your lordships, my lord. No.
Yes.
My lord, on this issue, my submission is the application has been forwarded in the belated stage. Number one,
No, no, that is forwarded by them, by the authority concerned. So why they should be held responsible for it?
my lord, the ultimate authority is the DPI. DPI received in the year 2014. 2014, my lord.
If, let us understand.
Yes, yes,
simple things.
I have understood.
If
your
you have
lordship.
understood simple
Yes, yes,
things,
yes,
then why you make it look like complex?
Yes, my lord.
Question is that today he died. Suppose today a person died. His son make an application tomorrow for a compassion appointment. And you follow it after 2 years.
And everything,
Then what will happen? His right will go. Because
Yes.
by that time, another application has, another policy had come.
but in this judgment, the apex court observed that delay not only ground of the on the date of submission.
Delay on the part of the authorities of the state to decide claims for compassion appointment would no doubt frustrate the very object of the scheme for compassion appointment. This judgment you have handed over to me.
Yes, my lord, kindly. mm,
Probably দেবব্রত theory. এটা কি দেবব্রত theory?
বলছি।
It may not be entertained after a lapse of a considerable period of time since the death of the government employee. Now, it
Yes.
is whose responsibility?
Yes, my lord, kindly see the paragraph policy of compassion number 7.5. Sorry. 7.5, my lord. Page 10.
Yes, you must decide it when he applied, and that has to be decided
Yes, my
on
lord.
that.
Here Supreme Court kindly see 7.5, my lord.
Yes.
Considering the second question referred to above in the first instance regarding whether application for compassionate appointment could be considered after a delay of several years. We are of the view that in a case where for reasons of prolonged delay, either on the part of the applicant in claiming compassionate appointment of the authorities in deciding such claim, the sense of immediately diluted and lost.
You read again for yourself and explain
Yes.
to us what does it mean.
Yes, my lord, we are of the view that
No, please read it for yourself and explain to us what does it mean.
we are of the view that in a case where the for the reason prolonged delay, either on the part of the applicant in giving compassionate appointment or the authorities in deciding such claim, sense of immediately diluted and lost. Either on the
But in the present case, the petitioner
lord,
applied.
here is a two ground, either on the part of the applicant in claiming compassionate appointment
Paragraph you
or
are reading? Which paragraph you are reading?
7.5, my lord. 7.5, page 10.
কপি আপনার কাছে আছে কিন্তু আমার কাছে সেটা আমি ঝামেলা করছি
Yes, these are the considerations. So today, in deciding it, if you find that there is a, that there, suppose he became a millionaire, so he doesn't call for it.
Yes, my lord.
So
The-
7.5 does not mean, what does it say? It said the sense of immediacy is diluted and lost. Further, the financial circumstance of family of the deceased may have changed for the better. So these consideration, where is the ground for rejection? Your rejection does not say anything of this. Show the order of rejection.
DP
Show your order of rejection.
considering the 251 memo that has been rejected, because of that 2014, the authority DPI has received the
You have rejected it on the ground that the has
Your
no
Lordship
scheme
kindly
or
come to
policy.
annexure P9, page
He
34.
has no scheme or policy regarding offering appointment. Now, when
pertinent to mention that the higher education department of the state government has no scheme or policy regarding offering appointments on compassionate grounds in commended college. At present, further, the labor department, government of West Bengal, geo number such and such dated is not.
well, take down.
My lord, before that,
The
my lord,
appeal and the application are
my lord, kindly,
taken up together and disposed of by
kindly
this
allow
order.
me,
I am appearing on behalf of the university because of the college authority.
College.
Nobody appears in spite of service.
Including the college authority.
Yes, the college.
Number 160.
My lord, I am for the appellant, Mr. Soumen Datto is admitted to hospital on 14th of August. My lord, next week kindly be fixed.
কোনটা?
হঠাৎ করে
এটা কত? Weeks old. Shandeep.
I'm for the rest.
Item number 161.
This is for the writ petitioner, the
Malad.
appellant.
I am for the
You are the
appellant.
appellant.
Now, Lord, state has filed this appeal. Now, my lord, there is a considerable, my lord, period of delay. Now, my lord, even after, my lord, the taking note of the Honorable Supreme Court's, my lord, there's judgment, whereby, my lord, the delay, my lord, the excluded from 15th of March 2020 to 28th of February 2022. Even after, my lord, giving that, my lord, taking into consideration of that, and then again 90 days, that judgment is with me, lordship. My lord, delay is actually, my lord, now 309 days. Now, my lord, in the application for, my lord, the section 5 application for condemnation of delay, my lord, elaborately, my lord, it has been, my lord, narrated.
Just
My
give
lord.
us 2 minutes. You are for the writ petitioner.
I'm for the.
Just. Yes, but this law, we have also settled this law, higher scale of pay before the Expenditure Act. So Justice Saraf has merely followed our decision, division bench.
My lord, well, I have no, my lord, no issue with regard to that.
We condone it and we dismiss it.
No, my lord, the issue is not that. And I'm grateful to your lordship, my lord. Issue is not that. Issue is that, my lord, that,
We'll condone it.
my lord, the more than 56,
Take out.
my lord, may I tell? Yes.
We condone it for the timing first. We have
Lord,
got the land council for the parties.
Million, it is their own avertment that the appeal is almost 1 year and 8 months delay.
There is. But he also entitled to get the benefit of the COVID. So ultimately it comes to 309 days.
So that is
So
also
fall short of 1 year.
also sort of 1 year, but not a.
Yes, now the real problem, yes.
But I think, well, I can overcome this, my lord, so far the present matter is concerned. Now, my lord, before, my lord, going through the, my lord, the pleadings, my lord, what is the fact that why, my lord, I have come up before your lordship? Now, my lord, the thing is this, my lord, in total, my lord, 56, my lord, writ petitions were taken up, my lord, analogously. 56. My lord, if your lordship, my lord, may I tell lordship, my lord, 56 writ petitions were taken up analogously. And by this judgment, my lord, all 56 writ petitions were allowed, taking note of the, my lord, consideration that all 56 writ petitioners, they were teachers, which were not the fact. So for the present writ petitioner, my lord, he was my lord, the librarian in a school. He is not a teacher. He is a librarian. Now, my lord, when he joined in the school in 2008, my lord, he possessed, my lord, the bachelor degree. In 2008, he joined in the school with bachelor degree in the post of librarian, not as a teacher. And then in 2011, my lord, was a candidate for, my lord, the master degree examination. And he succeeded. She succeeded in the master degree examination. After that, as a librarian, my lord, she made some representations one after another. And my lord, the only, my lord, the relief that shortfall in the representation followed by repetition is that in ROPA 1998, in ROPA 1998, there was a provision for even for, my lord, the librarian, that if he or she improve his qualification, then, my lord, he could, my lord, claim and or would be entitled to a higher scale of pay. In ROPA 1998, yes, my lord, there was a provision in clause number 12, possibly I shall show your lordship, that even a librarian, after having improved his qualification, then he can, my lord, entitled to higher scale of pay. This particular librarian, being the writ petitioner, he joined in 2008, no question of ROPA benefit, because when he joined in 2008, 2009 ROPA came into effect, and tab 2 came into effect from 2006. And in 2009 ROPA, there was and there is no such provision with regard to that claim of, my lord, higher scale of pay on the basis of improvement of qualification. Because he joined in 2008 in the school, she sat for examination for higher qualification in 2011. And by that time, ROPA 2009 came in 2009, but with effect from 2006, January. And in 2009 ROPA, there was no such provision as it was in, my lord, 1998 ROPA. Be that as it may, in the writ petition, my lord, while disposed of by a, my lord, common judgment and or order, relying upon an earlier order of, my lord, that coordinate bench, that yes, in case of teacher, that, my lord, the Expenditure Act section 24, that is applicable in case of teacher. So all teachers are entitled. So a person who does not belong to that class of teacher, he is a separate class. He is a librarian. A librarian is not defined as a teacher in the Expenditure Act, section 2 definition section within bracket P. Teacher means a teacher, but not, my lord, the librarian. But the order, if your lordship kindly have a look at the order, if your lordship, have your lordship got it, my lord, the impugn order. The impugn order is that the first paragraph, all the writ petitions relating to drawing of higher scale of pay upon securing postgraduate qualification as governed by West Bengal School Control of Expenditure Act 2005.
You're relying upon,
My lord,
you are showing.
my lord, the impugn judgment, that is, my lord, at state petition page 18 and at page 19.
Yes.
Page 19. These writ petitions are taken up for analogous hearing. In total, 56 writ petitions. And this particular petitioner was not a teacher. All the writ petition relate to drawing of higher scale of pay.
Teachers? Who are teachers? How many of them are teachers?
My lord, we have, my lord, after scrutiny, it appears bearing 3, rest of those teachers. And out of these 3,
we will hear on this, but so far the teachers are concerned, it is.
no, I am not on them. I am not on that. This writ petition is strictly only, my lord, in respect of that, my lord, particular writ petition.
No, you have challenged this order.
I have challenged this order only to this extent. My lord, if your lordship kindly come to the paragraph, page number, running page 16, and my lord, the order page 3.
Sagorika Bhattacharya.
Sagorika is, my lord, internal page 3 of the order, my lord, last but 1, Sagorika Bhattacharya, WPA 13100 of 2019.
No, see, you are challenging.
I am challenging only in case of Sagorika.
Only
In memo of
Sagorika.
appeal. Yes, my lord.
Others you are accepting.
Others, yes. Others we are not challenging.
Oh, Sagorika is a librarian.
Sagorika is a librarian. Admittedly, my lord, writ petition also, my lord, copy is with me. Copy of the writ petition. There is no denial, I think. Cannot be.
Yes. And my lord, only thing,
Then that judgments will not apply to Sagarika.
my lord, I will try to satisfy your lordship, my lord, because in my humble submission, I would say, my lord, that the very learned advocate who
No, who have, see, I'm sure that when this was decided by Justice Saraf, his lordship, we could find out from the references, the judgments that were relied upon are also with all teachers, not with regard to the librarians. So, as Mr. Sen has very rightly and fairly said, that he is not disputing because he is bound by the coordinate bench decisions. And I don't know whether they have gone to the Supreme Court or not. We have no idea, Mr. Sen. Those two decisions have been challenged by the state or they have accepted it.
My lord,
Meghnad Rai and
my lord, immediately, my lord,
Very
I
well.
cannot, my lord.
and in any event, the state is accepting it.
My
So there is no difficulty on that. So far
My
as
lord,
your,
only thing, my lord, in the read petition, one, my lord, page only, one
is
page.
it not annexed? Is it not annexed?
No, my lord, read petition has not been annexed. It was drafted by somebody else. It's my change brief. If your lordship kindly have a look, this was the, my lord, the final, my lord, the representation before the authority, and it has been annexed to the read petition. It is part of the record. My lord, read
No,
petition.
we'll do this.
No, read petitioner himself says.
We'll do this. We'll direct the learned single judge to decide this writ petition afresh
Might.
on affidavits being filed.
Might.
Because this order has
Yes,
proceeded on the
yes, yes.
basis.
This has not been gone in.
Because the judgments which were relied upon and considered by the learned single judge are all in relation to the teachers.
True. My lord,
So this issue was not addressed. So by mistake,
my
obviously.
lord,
So
possibly,
only
yes.
this writ petition should be heard separately.
My
Say down.
And my lord, so far the this order, my lord, we said as other contempt is pending, my lord. They have filed
That
the
writ petition should be heard. This writ
they have filed the contempt petition.
তার
So
মানে
this
কি
order
হলো?
we set aside.
My lord, and my lord, say,
Just file an affidavit and decide.
my lord, we will file.
You have filed your affidavit in the trial court.
I shall file this.
Have you filed it?
It has
No,
not
no,
yet
no.
been. On the very day, on I think on the first day.
No,
of the matter,
because you
clubbed
see,
and-
because of the judgment already prevailing, so you have, your affidavit can improve upon the situation. So that is why,
No, I think no, there was a mistake on the part of the lawyer also, I think.
yes,
So I am not
that
on
his
that.
point was not.
But so far this issue is concerned, my lord, it has, my lord, it is not covered by the judgment. So
The-
far Liberian is concerned.
Yes, take down.
So far Liberian is concerned.
The appeal is arising out of the judgment order passed that neither the provision of the West Bengal school nor the relevant government circular bearing such and such is applicable in the case of granting higher scale of pay to the librarian upon acquiring a master of that librarian.
my lord. Neither the circular nor the any judgment.
No, but you see what they have asked for. They have asked for the one that you handed over.
My lord.
The school authority was requested to submit paper, but no government order circular has been mentioned in the said communication, by which permission is required.
Yes, that was the. yes.
Permission is required from the DI of the schools for enhance of such qualification,
Mhm.
namely Master in Library Science.
Yes, and then
Now,
the last page
that
annexure.
neither the provision of the West Bengal Schools
Yes,
Control of Expenditure Act nor the
admitted fact, it is there.
Uh,
That it is not applicable,
is
but on the basis
is
of that,
applicable in the case of granting higher scale of pay to the librarian upon acquiring Master of Library Science.
it is their case in their
Yes.
representation, but when the writ petition
The
club took it-
entitlement of postgraduate scale of pay was extended to the librarian in the ROPA 1998.
ROPA 1998, but ROPA 1998 on merit is not applicable in his case because my ROPA 1998 is no more because of 2009 ROPA giving effect from 2006
No, no.
and he joined in 2008 and my lord, he improved
Which has-
qualification in
Which
2011.
has subsequently been revised in the ROPA 2009.
It's 2009 and there is no such provision which has been given effect to from January 2006. And he sat for examination in 2011. And so there is no question of giving effect of ROPA that 1998.
These in Meghnatra and others, they were getting the benefit under ROPA because of the higher qualification.
Here, my lord, it is
Bolna?
not applicable.
Bolna? Including physical education teachers and librarians of secondary schools who have improved or will improve their qualification, who are appointed with higher qualification in the subjects of groups. So 12.3 is there,
In 1998 ROPA,
correct,
1998 ROPA.
but this
Then
was excluded
subsequently, when 2009 ROPA came into effect, then my lord, there is no such provision.
No, but when
And-
when she was appointed,
He was appointed in 2008.
so 1990 ROPA was in force.
No, 1999, 2009 ROPA.
Sorry, 98 or 99.
92,
For 10
2009,
years.
2009 ROPA came into effect from my lord January 96, 2006.
Yes.
And he, my lord, improved his qualification in 2011.
No,
And
but-
the language of ROPA 1998
No,
was
so-
in the, my lord, that those who had already joined, those who already joined, already in service, kindly the language of my lord, that particular clause 12 of my lord, the 1998.
No, it says that all teachers, including physical such and such, shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later. So she improved her qualification when?
2011. কোথায় গেল?
No, but she will be entitled to the scale of pay under ROPA 2009, whatever the rates.
ROPA 2009. There
Will be
is no
entitled.
such provision with regard to, my lord, the enhancement of qualification. Otherwise, whatever the, my lord, that is separate thing. Whatever the benefits percolates in 2009 ROPA, effective from 2006 January, there is no such issue.
কি বললাম?
Last but one. That's it, kindly, my lord. Yeah, at the bottom, internal page 3.
But my lord, kindly
131100 of 2019, Sagorika Bhattacharjee versus the state of West Bengal and others. In the third page of the running page, third page of the, my lord, the impugn order or judgment.
WP? WP?
WPA 13100, third page, bottom. Last but one of the order, impugn order.
in the call.
WPA 13100 2019.
13100 of 2019.
Full stop. The state shall file an affidavit indicating the state shall file an affidavit in the writ petition indicating the distinctive features which may distinguish the case of the writ petitioner from the others within 2 weeks from date.
Within 3 weeks, my lord. For abundant precaution, my lord, within 3
from
weeks.
date.
Lord, point out only one thing, my lord. Kindly see, my lord, her letter of appointment, it has been mentioned that she was appointed with effect from 23rd December 2008. Admittedly, my lord, 23rd December 2008, her right accrued. Now, my lord, this ROPA, my lord, came into force, my lord, on 27th February 2009. Now, what my learned friend is saying, my lord, my learned senior friend, that this ROPA has been given effect from an prior date, that is from 2006. But by that, my lord, perhaps they, my lord, cannot take away my right.
No, whatever under ROPA 2009 you are enjoying, you are enjoying.
Yes.
We are not on that. Question is this, that whether this was.
I
will
joined
extend to-
service prior to this ROPA, so my case has ought to have been considered under 1998. That is what I.
No, 98 is 98 ROPA is from, with effect from 1st January 1996. It ended in 2006.
2006.
You joined, when you joined,
2008.
then ROPA 1998 was,
Enhanced qualification 2011.
yes, you enhanced your qualification 2011. In all those cases, Meghnad and Hadat, they were pursuing their higher qualification at the time when they joined. So we said that there is no question of any prior permission required under 14.3 in any event. For the benefit of the institution, there could be a ex post facto thing. On that basis, we decided. And we have not decided on the case of librarians as such. He said whether the same principle will apply or not. That's why he let him file an affidavit.
Yes, let it be
If there is
here
no
out.
distinction, no distinction.
Yes,
Same principle will apply.
let it be here out before the learned single judge. Get full.
Yes.
Madam, for the appellant, madam.
Your for?
Appellant, read petitioner.
162.
For university.
Madam,
Your for?
Respondent number 3, principal accountant.
Now, petitioner before your lordship is the retired principal of a college. He filed a writ petition before this honorable court challenging 2-4 grounds. Firstly, he paid for 24 days lordship, leave encashment benefit, which has not been given to him, and also for interest to the delay payment of all the lordship, the pensionary benefits. Now, my lord,
So 24 days less.
yes.
No, but just for query that this particular these leave rules,
my lord.
they were notified on 7th May.
Yes,
Or rather 26th April.
yes,
It is after you retired.
yes. But my lord, the government subsequently published a notification giving effect to the rules from 2009. Will also kindly come to the supplementary
Very well.
affidavit.
So now, but you have submitted that, no, not you, Director of Public, who is Director of Public Instruction.
State of affairs.
So, Your Lordship, Mr. Amitabh Chaudhary is appearing for the
Where is he?
DPI. He's engaged in another court, Your Lordship.
You are the disbursing authority. You are the
No.
disbursing authority.
Disbursing officer is the state. We only calculated the
Yes,
pension payment order,
PPO.
PPU,
No, but
handed it over.
his case is that if you go by the 2009 or whatever retrospective effect, then he's entitled to 300 days.
No, the issue has been raised by the university. Vidyasagar in the university, that they have implemented it on 25/3/2020, 2030.
Will also
The
kindly
page
look into
takes
my supplementary affidavit.
19.
I've annexed the entire notification, all the notifications.
Vidyasagar in the university was a part of the my lord, meeting in which the governor took the decision.
In which?
In which the governor took the decision.
No, for what?
Formal implementation from priority.
No. You see, that is the circular leave encashment rules.
19, page 19.
That is a leave encashment rules. Now, leave encashment rules, if it is given retrospective effect from 2009, as your learned friend says, then on that basis, you have to calculate his leave encashment.
Yes, my lord, but page 23 is my lord Vidyasagar University, his supplementary affidavit.
Page 23.
Well, kindly
After
look into my
suppli-
supplementary affidavit.
Supplementary affidavit. They
Already
say
on
that they
record.
have accepted it on 25th of March 2013.
Yes.
Here lies the whole
My lord,
problem.
first, my lord,
Now,
the
if
kindly
they accept it, no, just how that acceptance make the difference?
my lord, if you also like,
Kindly
firstly
come to
come look
Just
into
a minute, just a minute.
Page 19. Paragraph 3 and 4. Paragraph 3 is the whole minute issue.
Paragraph, page 19.
Page 19, paragraph 3. Concerned universities will make amendments in their statutes, public ordinances, rules, etc., where necessary for incorporation of the provision of the government order therein. But 4 says, this order will be effective from 28th of January 2008, except fixed otherwise in any particular rule in this memorandum.
Yes.
Now the Vidyasagar University is taking advantage of this. There's no such provision in this rule that they can take a decision contrary to that.
But they cannot take a decision contrary.
But my lord, this is not a rule under 309, Article
No,
309.
but this is a rule under,
This is not a rule under Article
no,
309.
it is a
kindly
rule
see
under,
page 4.
My lord,
this is a rule under which provision?
my lord, these are acceptance rule my lord, on all the university acts. The governor is the vice chancellor of all. Despite that, they have taken such a decision. They are objecting on this score only.
But kindly look into page 5 of the supplementary affidavit. This is the rules which was amended. Page 5. The amendment of leave rules for teachers of government aided, including erstwhile sponsored colleges in the state under Vidyasagar University. But this dated 7th May 2013.
Yes.
Now, but kindly come page 4, the next page. The before page 5. Is the proposal for amendment of the leave rule for the whole-time teachers and principal of the affiliated colleges, erstwhile sponsored colleges of the Vidyasagar University under Part 2, under Chapter 9 of the Vidyasagar University First Statute, up to date amendment in tune with the provision of the department geo number so and so, 3rd December 2009 and 17th February 2011 was under Act
Maximum leave encashable shall be 300 days.
300 days. Now let kindly come to page 4 now. The notification of the government.
Now, why this shortfall is coming? Now, why this shortfall is coming?
And this is DPI and my lord Vidyasagar University.
Where is it? Have you
Ms.
searched
Dasgupta-
Vidyasagar
Yes, they are all along they are appearing, my lord.
Ms.
They are all along
Dasgupta
appearing.
first is the
Who?
issue.
No, but college has sent for 300 days. DPI instructed the college, no, not 300 days, give him 276 days.
Why?
My lord, kindly see the documents. My lord, kindly come. Page 29 of my application. But this has been this document has been sent by the college to the DPI.
So the college recommended for 300
300
days.
days.
Yes.
DPI Suomoto lordship decreased it to 76 days. Now, my lord, if you lordship kindly look into the supplementary affidavit once for my satisfaction, lordship, kindly look into my supplementary affidavit, page 4.
No, but the basis of the reasoning is wrong. If what you say is correct, that I am of the view that the petitioner was not entitled to the benefits of the said rules since he retired on 31st March 2013.
But correct, my lord, but kindly see now page 4 of
No, no.
supplementary affidavit.
So these rules will not be applicable to him.
As per the rules, I am not applicable to me unless this notification came into effect. The page 4, government has passed a notification saying that all lordship the benefits should be given from 2009. But kindly see
No, but
page,
that was not reflected in the order.
yes, that was not reflected in the impugned order of the honorable single judge.
Has it brought to the notice of the learned
No.
single judge?
But for respectfully submitting, no.
Then
No. But kindly see page 4. The matter of allowing cash in equivalent, but this dated 20th December 2013. I retired 31st March 2013. The matter
that
of
we have
allowing
seen. No, that we have seen. Where is Mr. Chaudhary?
Your lordship, he is engaged in another course, your lordship. In courtroom
He's
number
appearing for.
238, your lordship.
He's appearing for.
DPI, your lordship, in this matter.
DPI's presence is required because they declined. Why is the letter of DPI declining it?
No, my lord, that is in the record. Other day it was filed before your lordship. Before the honorable court.
File করেছে?
And this honorable court pleased to direct me to file an exception to the
হ্যাঁ, file করেছে।
copy. Report. But I have a copy, but if it is
Just
not, if you lordship got it, my lord. The DPI not even considered the notification dated 20th December 2013.
Oh, this was adapted by the university after April. That is a problem.
They have their own
That is the
statute.
The
problem.
government says whenever maybe the university adopted, it will be given effect since 2009. That is what my lord, page 4 of my supplementary affidavit.
Who is for the state?
Lordship, I am appearing for the state led by Mr. Shantanu Kumar Mitra.
What?
Lordship, I am appearing for the state led by Mr. Shantanu Kumar Mitra.
Yes, your government has said that this will be effective from. But it says, subject to the universities amending their statutes in this regard. So it is subject to the amendment.
Yes, my lord. Amendment was done in 7th May 2013.
So after you retired, that is a
After my
problem.
retired.
So after
Number-
you retired, then obviously, if you retired in March, then you are
But
not.
amendment came into effect 7th May 2013. But these notifications says subject to university amending their
Yes.
statutes, that
So
this will
amendment-
take effect from the
Subject to the
3rd
universities
December
amending
2009.
statutes in this regard. Subject to this will take effect from 3rd December 2009.
2009.
Retrospective effect.
Retrospective has been given by this notification.
Yes,
My lord, your lordship kindly sees, my lord, we have filed a report in pursuance to the direction of this honorable court, my lord, on 8th, my lord, May 2023. If it is
No, no, দর্শক দেখেছেন স্যার।
দেখেছেন এটা? DPI তো আলাদা অ্যাডভোকেট দিয়েছিল। আজকে তো নেই। এটা বলে দাও।
কিছু আছেন তিনি আর আছেন।
ওনার
কি time
রিপোর্টটা
চেয়েছে?
No, sir, sir, sir.
ওনার রিপোর্টটা হবে।
Let us start here.
টাইম চান নেই। বলুন আপনি ডিপিআই এর আছে। কথা না বললে কি করে আছে? Lord, internal page 3, your lordship would get. নিজেকে ফোন করুন।
Sir, sir, thank you, sir.
এখন আর টাইম চাইলে দেবে, প্রথমে টাইম চাইতে টাইম চাইলে দেবে এতক্ষণ সময়।
Who is the disbursing authority?
Subject to correction DPI.
Now you
DPI.
see. So far as the University, Vidyasagar University Act was amended later, no doubt. The amendment was done on 25th March 2013. Concurrence of the Honorable Chancellor on 26th,
Yes,
and then it came into effect from 7 May.
7 May 2013.
So obviously, whatever benefits would be, that should be from 7 May, no problem. But at the same time, you have issued a circular. That is your circular and you need to explain it. What would happen to this circular that is referred to?
Since
That is 20th December 2013. That is your circular, which says, after careful reconsideration such and such, the Honorable Governor, that it is further clarified that every whole-time teacher and principal of government-aided colleges, including such and such, shall be entitled to leave salary of the earned leave accumulated at his or credit. Then you go down, encashable shall be 300 days. So 20th December 2013 is your circular. Have you got it? Even supplementary
Supplementary affidavit, my supplementary,
It was there, yes, this supplementary affidavit, in the supplementary affidavit. they have
page
given.
4 supplementary affidavit.
So by reason of this circular, because he retired on 31st March 2023. When he retired?
31st March 2013.
2013.
31st March 2013. And this is of course letter memorandum,
Lordship.
but it says,
Lord,
the last paragraph,
it has not given retrospective effect.
no, subject to the universities amending the statute in this regard, this will take effect
Yes.
from 3rd December.
Yes, taking into account this department geo number such and such.
So once the university amended, but by reason of this memorandum, so far as those teachers who may have retired by this time, these 300 days, this benefit will go retrospectively from 3rd December 2009. What would happen to that?
Lord, may I come back,
Because you see, he is correct. DI has said that doctrine of relation back will not go, because once the amendment takes place,
Yes,
it is effective from that date onwards. But for the purpose of giving benefit, you have a circular, which now this circular is, one is the one is the amendment of the statute of the university,
Lordship.
and the other is your circular dated 20th December 2013.
Lordship, Lord.
And there also, the governor on reconsideration has enhanced this to 300 days. And governor is also the chancellor in Vidyasagar University.
Yes. Governor is the chancellor. Yes.
Then
May I get back in that?
because
Difficulty is this on the last occasion, Lord, I found out, Lord, DPI has, Lord, engaged his own advocate.
yes, Mr. Amitav Chaudhary is there,
Yes.
but irrespective of that, you see in this reasoned order, this 20th December 2013 has not been referred to.
In this order, my Lord.
Yes.
Not been
Not been
considered.
discussed.
Not been discussed or
Not been
considered.
discussed. That's why, my Lord, I am praying before your Lordship, my Lord, we would
And Yashoda,
get back.
you have heard the land council for the parties. Mr. Chaudhary is appearing for Director of Public Instruction.
Yes, sir. Yes, your lordship.
Good stuff. Someone should be here. We are not going to adjourn this. He must make alternative arrangements. We are not going to adjourn this matter.
Yes, your lordship. He will be there on the next occasion. Your lordship, he will be there in the next occasion, your lordship.
No, you are there today, but you are unable to respond to the query. So we want someone who can be there and respond.
Your lordship, your lordship. Your lordship, today is my 5th day of practice, your lordship.
It is your
5th day of practice. Day. Your lordship.
congratulations.
Thank you, your
So
lordship.
you have to clarify it to us, not your senior.
Your lordship.
You need to clarify it.
Yes, your lordship.
We'll hear you on that day. All the best.
Extremely grateful. Matter to appear next Thursday.
1 week.
Lord, I am for the appellant. Lord, affidavit of service.
And I am appearing on behalf of Kolkata Municipal Corporation.
My lord,
Yes,
my lord, in this matter, my lord, I am being led by Mr. Obrotosh Mojumdar's Planet Senior Counsel. My lord, on instruction, I am saying, my lord, if it can be, I am seeking an accommodation for not this week, my lord.
have you served?
Yes, yes, my lord.
Have you served all
Yes, my lord.
other respondents are represented?
Yes,
I am only for Kolkata Municipal
What about
Corporation.
the other?
Respondent number 6.
What about the other?
my lord, copy has been served, my lord, upon all.
Lay down. The personal difficulty of one of us.
Released.
Grateful, Your Lordship.
Grateful, my lord.
I am for the British number.
For the respondent school authorities.
In this matter, Mr. Sardar Amzad is reading me.
Mala, he's on medical ground, has gone to medical checkup. Mala, if your lordship kindly accommodate me, my lord. Mala, I have been requested by him, my lord, to make a prayer.
Well, take down. An adjournment is
He will be back on 25th of September, my lord.
কবে আসবে? হ্যাঁ হ্যাঁ 14 সেপ্টেম্বর। Great. হ্যাঁ দিচ্ছে দিচ্ছে।
এটা নিন।
165.
165, my lord, I am for the appellant restriction.
I am for the college authority matter.
My lord, I'm for the state.
এদিকে সরাই। My lord, impugn order, page 75. Stay application. An application for appropriate order. Page 75.
It's in the memorandum of appeal.
My lord, certain facts, admitted facts, not, my lord, discussed in the impugned judgment. Lordship kindly straightway come to page 41st. Same recruitment process, kindly come to advertisement, page 40.
Come after 40.
No, my lord, kindly come to page 40, please, Lordship, kindly. Advertisement, in the left-hand side. My lord, Lordship, kindly only, or 2 or 3 minutes, my lord. Page 40, left-hand side. Wanted application for guard 1 general, guard 1 reserve for scheduled caste and sweeper. Qualification such and such, my lord, Krishnanagar Women's College. That is the advertisement. And on the basis of the advertisement, other two, my lord, from the same recruitment process, kindly come to page 42. My lord, this honorable court, my lord, in respect of, my lord, other persons, my lord, this honorable court passed an order in favor of the impaneled candidate. But thereafter, that order was challenged by the, my lord, state. That order, page 49, governing body, page 49, division bench order, in respect of Akshay বিশ্বাস and others. They got appointment. That time, my lord, college did not say the panel was cancelled. Page 42 and 49. And thereafter, again, another candidate from the same selection process, page 51. Single bench directed for appointment, page 51. In respect of, my lord, Pintu Hari.
No, today, after 15 years.
No, my lord. According to the college, the panel was cancelled.
Yes.
But in spite of the cancellation of the panel, same recruitment process, other two candidates, my lord, one, my lord,
Happening suppose a wrong thing was done.
No, my lord,
But this is in
pursuant to the order of this honorable court, page 51.
2011.
No,
2011.
page, thereafter, my lord, thereafter division bench. That is page 49. Page 49, my lord. And another candidate, page 51.
When? All this happened when?
My lord, page 51, last 2022, CPN. Page 53, 51 order, and my lord, contempt order, page 53, 2022. And my predicament is that first candidate, I came to learn, he died in the 2017, but I came to learn 2022. First candidate, Ranjit Chaudhary died.
That panel may not exist anymore.
No, my lord, that time also, that stand, they never taken that stand. The panel was cancelled. 22, page 53, lordship, kindly have a look into. Page 52, 53, my lord. In the contempt proceeding, already appointed, my lord. And now, till last 15 years, my lord, I have been working as a casual. Page 53, kindly come to page 53, my lord.
It is not there in the, they have not
Page
annexed it.
53. My lord, contempt application. My lord, everything discussed by this honorable court by different three benches. One division bench, one another, two coordinate single bench, my lord. In respect of same recruitment process. And when Ranjit Chaudhary filed a writ petition, but unfortunately he died. And thereafter I filed the writ
No, no, you
petition.
see, if cancellation of panel is there, then it affects your right as well. You may be the second candidate. If the first is not there, you did not file a writ petition.
My lord, I filed writ petition after the death of Ranjit Chaudhary.
Yes, so Ranjit has filed a writ petition.
Ranjit Chaudhary filed writ petition.
As per the
Ranjit Chaudhary filed a writ petition.
Writ petition in respect of that post, but recruitment three post.
So
One
consequent
petition.
upon his death, you file a writ petition.
After the death of Ranjit Chaudhary, I filed writ petition.
Because he was the second panel
A
candidate,
second impanel candidate. And they say,
2017.
2000, they say, my lord, that panel is cancelled. That stand not taken, my lord, in respect of other candidate, my lord. That is not wrong, my lord. Here,
You have filed a writ in 2023.
my lord, my writ petition, well, I came to learn 2022.
Maybe.
And 23, I filed, my lord. My lord, page 55, my lord, what is record I am submitting?
That vacancy may not exist anymore. We cannot go on.
My lord, what has happened? But
2007.
that panel is still, my lord, lordship, kindly.
How this panel can.
No.
still work?
2020.
That has been in the order.
Which order?
Your impugned order which has been challenged, my lord.
Order, my lord,
But kindly see,
22, pursuant to the order of the honorable single
everything
judge.
has been
My
discussed.
lord, page 53, honorable single judge directed to have, but that time,
Question is this, it says. The
2022.
panel was cancelled on 30th June 2012.
Lordship.
The panel was cancelled on 30th June 2012. Then how these appointments are taken place?
Now, my lord, in the third paragraph, affidavit filed by the state suggests that after the panel was cancelled, the college authority sought fresh permission, the state seeking permission to initiate fresh selection process. The state has not yet accorded such permission to the college. Now, my lord, kindly, if his lordship kindly come to page 69 in the compliance report filed on behalf of the state, my lord, wherein, my lord, it has been specifically mentioned, it is stated from the that annexure P4, it is evident that the panel prepared in connection with the selection process held on 17/3/2010 is in the said college was cancelled and new prior permission has been sought for which is pending.
My lord, between how this appointment, page 42 come to page.
My lord,
42.
may I answer to your lordship's query, my lord?
Who are you?
My lord, I am representing the college authority, my lord. My lord, in the page 42, my lord, in the order, it was recorded that since the writ petition was filed during the lifetime of the panel, so therefore, my lord, the writ petition was allowed, my lord. And my lord, the next writ petition, my lord,
A
which is,
cancelled panel, someone was
my lord,
allowed.
they are, at that point of time, the cancellation was not, my lord, within the knowledge of the college authority, my
The
lord.
panel was cancelled, then their jobs were terminated.
No, my lord, that was, my lord, now, my lord, approved by the DPI, my lord.
Then
DPI, my lord, my lord, panel was,
cancelled, they were DPI, but any event, your
my lord,
case is not on the.
My lord,
panel was
my lord,
cancelled by the district magistrate.
Take out.
my lord, Lordship, kindly,
Take
my lord,
out.
district magistrate is the president of that college. My lord,
College.
district magistrate is the president of that college. They did not take plea, my lord, at the time of other two candidates in the year twenty
Because
twenty-two.
whatever has happened has happened. Suppose something is done wrongly, doesn't mean that you have.
That is not wrong, my lord, division
Take out.
bench order, my lord.
The
Lordship,
appeal is arising
Lordship,
out of
kindly
an-
direct the DPI to consider my representation, my lord. Lordship, kindly. My lord, I am working for last 15 years, my lord. Lordship, kindly.
the appeal is under what consideration they will.
My lord, but under consideration of
What?
the
What?
my lord,
What consideration?
my lord, division bench judgment as well as, my lord, single bench judgment, my lord. And they are not
The
taken
appellant-
that plea
The appellant
at the
was
time
a
of the
second panel candidate
And that,
Page-
that,
page-
my lord, the process has been
69.
page 69, my lord.
He stated in the affidavit has stated that
Or upon this court, my lord. That time, in the year 2022 also, my lord, they never
Tell
said,
you, your case is completely barred because the person who challenged it, he lost in the writ petition. That order is binding on you.
Yes, my lord, in 2022, my
That
lord,
order is binding on you.
my lord,
By another writ petition, can you reopen it? It's a res judicata completely, and the appeal has also been dismissed.
my lord, first candidate,
Yes,
writ petition.
yes.
That writ petition,
So you could have, if there was a decision saying something that he was eligible, then possibly you would have a locus to say that since he is not there, my case may be considered.
my lord,
But
that
his case was dismissed on merits.
merit thereafter appeal file, my lord.
Appeal is abated.
Abated.
So that for the learned single judge, that decision is binding.
and my lord, two order was passed in absence of the any representation by the college authority.
Unappointed.
Don't open your mouth, please.
হয়ে গেছে।
Don't open your mouth. You are not a holy cow.
Grateful.
166.
Copy of the memo appeal has not yet been sought. In spite of direction,
Sorry,
I
sorry.
do not understand.
Lordship, I am for the appellant.
Yes,
Yes,
you have been
Yes,
served.
I am appealing for the UGC, University Grant Commission.
Yes, yeah,
Copy of, stay application I have received. Copy of the memo appeal direction.
That forget about. Tell us what is the matter.
Lordship, the appellant has worked under UGC for continuously for 3 years, Lordship,
For?
3 years.
Yes.
And after that, he has been terminated for no reasons. And then he has filed a writ petition in the year 2002. And the coordinate honorable single bench pleased to direct the organization that he should be reinstated without any condition, Lordship, if there is any vacancy.
Just.
But what they have done,
Just.
yes, Lordship.
My lord,
Now, who are the other candidates who were given appointment according to you?
Yes, Lordship, there are candidates. They are Neel Kamal Das, Malini Shaw,
What you
Himalaya.
have said.
Yes, I'll come to the page number, Lordship. If you come to page 92 to 94, that is, first if Lordship comes to page 131, Lordship, that is for the Neel Kamal Das, who has joined him in the same year. And no examination has been taken out and he has been appointed, Lordship. In the page 131, Lordship. There are 2 pages, Lordship. In the 135 also, he has been appointed, Lordship, without any examination, nothing. They both of them have joined
No,
together.
you see, he was appointed as peon by the UGC.
Yes, Lordship.
You were not appointed as by the UGC.
Contractor employee.
Absolutely, Lordship, because what has happened when they have, if you come here, Lordship, in this page,
Your appointment and his appointment are not the same.
not same,
But-
but they both of in the contractual.
Maybe one is a contractual by the UGC.
Yes.
One is hired by a agency
Yes,
who was
Lordship.
entrusted to do the job for UGC.
What they have done.
So they are not on the same equal footing.
Yes,
They're
but
not on the
what,
same footing.
not the same footing, but if Lordship
Then-
comes in the page 94, Lordship. In
No,
the
then how can this be
Yes,
directed?
Lordship, in the 94, in the page 94, both of them, lower division clerk and the typist and the peon, all of them are in the contractual basis. No, here,
Madam, you are
the
again
crux
missing
is
the
here,
point.
Lordship, because they have,
Source of recruitment was different.
yes,
One was a directly contractual employee
yes,
of the UGC.
yes.
Other is through an agency. They
He
can
was also from the agency, Lordship, both of them. Neel Kamal Das was also from the agency.
from the agency.
Yes, Lordship. They
Where you
both,
have said
all
so?
of them, because
Where
if
you
we
have
come
said so?
here in the page
No,
94,
where you have said so.
I couldn't show it because it is in the 94 and 93 pages, Lordship. If Lordship comes here, it can be shown here clearly that in the letter in page 92, so after the decentralization, they have given this application to the UGC in the office of their central office. And they have given all the details of this because they have never recruited anyone through any examination or anything. All from after the decentralization from the contractual basis, Lordship. And these are the core people who have joined that time. Neel Kamal Das, Ananda Mohan Das, these are some people who have joined that time. All have been paid through the contractual basis, Lordship. Now, later on, when I have asked for the documents, it has never been given to me. So I couldn't show it.
They asked you money, 2,500. You deposited,
2,500 for the RTA, Lordship, it has been asked.
yes, have you deposited that amount?
Yes, has been deposited. This is the reason. This is for the only RTI. They have asked for money also. And other candidates are also there, Lordship. If we see Malini Shaw, page number 117 and 120, Lordship. Here also in the Pune branch, Lordship. In their Pune office, she has been considered on the same way. Ex-cadre post.
Stay down. Who are the other persons?
Other persons are here, Lordship. Himalayan Nijhar Nayak, who has been appointed in the same post, Lordship.
When?
With Ananda Mohan Das.
Page?
I'll come here, Lordship. In the page 138, 139, RTI reply, Lordship.
Did you file any affidavit before the trial court?
Yes, my lord, I have filed, I have stated, my lord, he was appointed, my lord, by the contractor. I am not appointed. UGC has not appointed any person for 58 days. My lord, kindly.
Question is this, Mr. Gupta.
Yes, my lord.
If this, you see the order in 2002.
And this is, my lord, kindly see, this is the third lead petition.
First writ petition was disposed of, thereafter second writ petition was filed, dismissed for default.
The first writ petition.
My lord, this is the
Please
third.
allow us to speak. In the first writ petition, there was a direction by the learned single judge on 6 March 2002.
Yes, my lord.
The case of the petitioner be considered for recruitment such and such. You file an affidavit how you have complied with this direction.
My lord, kindly
File an
appreciate.
affidavit,
I
showing
shall
the
file
compliance
affidavit.
of this
I
order.
shall file affidavit, my lord.
Take it out.
Before that, my lord, kindly
The
appreciate
UGC
also,
shall
my
file-
lord.
The UGC
This
shall
is-
file an affidavit. They were all absorbed.
Yes, Lordship.
Yeah.
And subsequently, what they have done, I have no idea, Lordship, about that. But all of them have been absorbed. One 138, 139 in the RTI application, Lordship, it's been given reply.
And also ask my lord whether he has participated in that proceeding.
Himalayan.
In 148 and 173 page, Lordship. One is in 148, another is 173. And this has been given in the reply also.
That's all.
Malini Shaw 2, Himalayan Nidhar Naik 3, and the other one is Kavita Shah.
Nilkamal Das is mentioned where?
Nilkamal Das is mentioned in 131 page, Lordship. They have joined together, Lordship, in contractual basis.
True.
Nilkamal Das.
Das.
Yes.
and a charting is করবে, the affidavit must also in
Well, that's why, well, office already closed. Eastern Regional Office already closed.
let's see, file in 3 weeks.
And 4 weeks, my lord, kindly 6 months.
3 weeks.
My lord.
Sure.
One, my lord, one thing I must tell you, Lordship. I was on impressions today. My Lord Justice Kumar will sit, the Honorable Chief Justice. Just now, accordingly, I fixed some other matters because one, the retired judge daughter's case, so I'll have to attend. Otherwise, there's the oh, Pasha thing. So that's all problem. So after 2:30, I'll start. I'll go. Next matter is ready. I inquire. And I assist. Yes. So let me start, my lord. Kindly please allow me to leave.
No, then you start on some other day because we.
As well as is my lord. No.
Others, all our others have completed.
Yes. It's my turn. And today I was really ready. But as I'm told, Justice Kumar was sitting with Justice Chief Justice. Even in the first half, nothing was informed. Just now I came to learn.
When that matter is fixed.
This matter?
No. The other matter you said?
Other matter today. Court. And I looked at it, there's no authority.
It was fixed earlier.
Maybe, well, that's true. There's no doubt about it. But kindly appreciate my predicament. And if I take the name, Milo also knows them. Very embarrassing. Very embarrassing.
Peaceful hearing would not.
My lord?
Peaceful hearing.
I don't like it, my lord. Today I was authorized today. I wanted to finish it, my lord, today. That's the problem. I want it.
We keep it on next Thursday.
Next Wednesday at 2 p.m. my lord.
Or Thursday, probably আপনার নিচ্ছে
Wednesday and Thursday হয়তো।
Hearing matter ছিল।
Probably Wednesday. I'm sorry.
Yes. Chalo. Here is Somnath.
No, move on. Keep going. No.
ওটা দিয়ে দিলাম নির্মাণ রচনা ওটা দিয়ে কালকে দেবাংশু অসাফের কোটে খাও
Thursday, any day, Wednesday, Thursday. Wednesday, very well.
So Wednesday, it will be the first half. Wednesday, first half.
Wednesday.
First half.
Well, at 2 p.m. is an inconvenience matter. Of course, I cannot dictate the court.
Tomorrow, 2 p.m. we are taking motions.
My lord, my friend is requesting me not to keep it on Wednesday, Mr. Gupta. Thursday, then at 2 p.m.
Thursday after 2, this bench will not sit.
Thursday, first half.
We don't want to delay this. We want
Thursday, first half, my lord. Thursday, first half.
First half, we have motions.
Oh, acha. Second half, my lord.
Let us please manage on that day. Otherwise, if we go on.
No, I am the culprit, but I'm helpless.
I know.
My position is very precarious, my lord. I cannot refuse. That's the problem.
But if you can manage there for today and.
Well, that will not be done because don't put me in trouble. If I take the name of Chief Justice, oh, is it? Acha. My lord also knows that lady.
Because you are addressing, we'll finish. Then Wednesday. Next
Wednesday, as it was. Kindly do not misunderstand me, my lord. I was fully ready with everything, my lord. I can't
Because we want to finish off this argument.
That's true, my lord. That's true. I also want that.
Mr. Gupta also make yourself available. So otherwise we.
Of course, they have finished their argument.
If they want to give some reply, because.
Yes, yes, no problem, no problem.
You know, on the prayer of the learned counsel for the appellant, writ petitioners. So the matters and section. On 23rd August.
You will just.
There will be one parter, I tell you. It will be the second parter, because one parter we are hearing.
Yes, yes.
After that parter is, Mr. Advocate General is addressing us. Soon after that matter is over.
As was first up,
Yes, second matter.
second matter. Well, I'm extremely sorry, my lord.
No,
It's my fault, whatever to do. Sometimes it has happened.
no, it's not your fault.
Yes.
First up, second
Mr. Bhattacharya will also hopefully available on that day.
This is first up, second man. Second.
First up, second matter.
May I leave, my lord?
Stop second matter, I think it will reach by 12:30. It will reach by 12:30. Don't worry, Ashwata, come ready.
No, we have one parter matter that will continue for maybe half an hour, 30 minutes. Half an hour. So it will be the second matter in the.
Second. Okay, no problem.
পড়ে গেছিলি শুনলাম।
কত হয়েছিল আমাদের? দেখে যাও 167.
I appear for the applicant.
Your other side is here.
Lordship, I'm for the state. In this matter, Lordship, Mr. Pinaki Dhol is appearing for the state. He is presently present in court number 9. So I seek pass over, Lordship.
Is against the main answering respondent will be the school service commission. Yes,
Let us have a first call because the list has collapsed. That's a problem. দেখে যাও দেখি কে আছে সেটা collapse করাবে।
Yes.
167 হলো।
168.
In this matter, I am appealing for the respondent number 6, my lord. I am appearing on behalf of the state respondent.
But who is for the Passover করে যাও দেখে যাও।
169. 170. 171.
I am appealing for the state, my lord.
You're for the appellant.
My lord, 169. Kindly give a short pass over.
Yes, yes, sure. Give us.
161.
171. You're for the appellant.
Presentation for tie and harness category, that application be considered. That is my only prayer before. My elder brother was unnatural death, and wife is the main cause of action. And my lord, let them consider. I am not paying anything. Only consideration order I am paying.
How can, because if the scheme says.
The difficulty is this, my lord, due to death of my brother, elder brother, unnatural death to his wife.
The scheme possibly said that you have to apply within 2 months.
I know that. But
Then
before
how that can be
before
condoned?
that, my lord, the unnatural death was occurred, and the wife of my elder brother is the responsible. FIR has been lodged. So this procedure, I am praying only, my lord, let him.
No, what basis?
My lord, praying to
What
consider
basis?
the representation, that nothing more.
It will be dismissed, we can tell.
It will be dismissed, let it be dismissed, but let them consider. My lord, I am only this prayer.
You have filed after 6
Because
years.
That I understand, but due to death
No
of,
explanation, my lord.
my lord, death of my,
The appeal is arising out of an order dated 11th April 2023 Is there a prescribed rule within which? Is there a time bar
This one within 2 years, my lord.
within 2 years? Is there counsel for the next matter?
Appeal. Dismissed. 172. 173. 174.
173, I am for the appellant. Lordship, advocate on record is suffering from fever.
Very well, we are not taking it.
Order 174, my lord, I beg to appeal of the appellate.
For the appellant,
Yes.
who is your other side?
My learned
But
senior
I am
friend,
for the private respondent number 10, but the answerable my lord, respondent is my lord, the school
We-
service commission.
will be my lord,
One
Dr. Patro, my lord.
Dr. Patro,
Yes.
where is Dr.? I have not seen Dr. Patro since morning. Let me pass it over once. Yes.
My lord will kindly forgive me, my lord. Board was showing 173, so I came running. I'm sorry.
No, it was just, very well.
But, that even let it be, my lord, not today.
Will basically we will want not today only. Just we are making a kind of a roll call. Yes, for the list. Because the-
Might be, my lord, it is a code number 18 day for my learned senior friend, Dr. Patro. Great. But my lord, he is on Lekin code number 22.
175.
Appeared for the.
Any matter, both sides are here.
My learned advocate on record just told me that 173 is the appellant's outside the court.
Who was 173, she asked for adjournment.
Oh man, I'm sorry. I'll keep
Both sides present.
175 is Mr. Shubir Kumar Sharnal is appearing for my counter.
Take it out, take it out. You are a Muslim.
176.
I'm for the petitioner. I'm for the petitioner. I was short passover, man.
Short passover, very well passover. Next.
177. 178.
I'm appearing for the appellant.
Other side, ache?
Yes, call the list.
179. 180.
I am for the respondent number 1.
181. 182.
May I prefer not today, my lord, on.
Yes.
183.
I am appearing on behalf of the respondent lordship on the last question directed to file the report lordship. Report had been prepared. I am submitting the report at the direction of the court.
170.
183.
183. We filed that out.
Well, I'm for the.
আমি ভুলটা যেরকম আছে রুল আছে আমার কাছে
Did not search the report.
you are not entitled to the report.
দাও।
প্রজেক্ট ডিরেকশনটা শুধু রিপোর্ট ফাইল করা।
তিনজনের নামে যে রেজলিউশন আর
ও,
Take also.
99,100.
It's my lot.
Copy একটা দাও। Copy একটা দাও। দিচ্ছি না, দাও। তোমার কিছু করে তোকে দেওয়ার ডিরেকশন নেই, তুই অর্ডারটা দেয়, আমি তো এমনি দিয়ে দেবো।
দেবে
তো দেওয়ার ডিরেকশন নেই তো, চর্চা দিয়ে দেবো।
Who is for the appellant?
I'm for the appellant.
Yes,
take the page 99. In terms of that, your lordship
now,
directed us.
just a minute.
Page 99 of
So,
the report.
this,
99,100.
so how you are agreed by this? Because the school has filed an affidavit disclosing that
Unless I'm go through the
the
report.
selection committee that the
Paragraph 5 to 9. 8.
8, paragraph 8, 7, 8.
see the paragraph 5.
5 to 8. They did not find. 8 is the clear. And that is corroborated with page 99 and 100 of the stay application.
And I want to file the exception in this report, my lord.
Exception.
My lord.
Exception, this
My lord,
question
on
of
the
fact.
next
exception
meeting,
is
there's admitted and accept the meeting, accept the resolution on the next meeting. I want to file that resolution, my lord.
No, who are you?
And
I'm for
being
the
a teacher,
aspiring
the
candidate.
teacher can access all these. How can?
Who are you?
I'm the teacher, and the then time I was the member of the managing committee.
You have filed a writ petition.
My lord, my lord.
For what?
For post of assistant teacher, post of assistant headmaster,
For the post of assistant
assistant
headmaster.
headmaster.
So it is this promotion through interview. It's a promotion through interview, internal promotion.
Not promotion.
Not promotion, my lord.
Or
But this is
It is the
additional post.
burden.
It's a additional post due to large number of student. Therefore, the post has been sanctioned by the.
So the learned single judge has directed for how you are agreed by this order, we don't
My
know.
lord, on that time, my lord, the process was not completed by the school authority.
How you are agreed by this order, you tell us.
My lord, to
Petitioner is complaining that though the district of schools hearing has accorded prior approval to fill up the said post, but for the failure of the school authority to take a follow-up steps, the said post is still vacant.
yes, yes.
The headmaster of the said school, the respond number 9, is directly issued notice inviting applications from eligible candidates.
Unless I was the only candidate who was applied for this post.
Yes,
There are two posts. There are two candidates was filed for applied for this post, and thereafter one has withdrawn due to transfer of the another school, and I was the only applicant
yes.
applied for this post. On that process,
And
the school
the DI of school has approved panel of 3 candidates. Supona Nandi, Anindo Dasgupta and.
it is
Bharat Subhash.
subsequent effect. It is subsequent, my lord. As
Yes.
per single bench order, my lord.
Yes.
My lord, I want to file the
No, single bench order if they are found to be more qualified, if they are found to be more qualified, because the institute require a more qualified teachers.
But my lord, the notification not said so.
Forget about the notification. A person who merit-wise he is more found to be more competent, he has been given a
No,
position.
my lord, have a look the notification first.
No,
My lord, kindly,
given the notification, what notification? Show us.
No,
Notification
even
say
though,
that no,
even,
no,
even though,
no merit
even though
will be
a single
considered.
person, even though a single person applied for this post, then said that, application should be, treated as a genuine, my lord. My lord, kindly see the notification, my lord.
Which notification?
My lord, sir, may I humbly pray, my
Which notification?
Yes, yes, my
Tell us.
lord, before that, my lord, I am humbly pray for adjournment, my lord,
Why?
I am led by Mr. Soumen Dutta, he is admitted
No, which
on hospital, my lord. That is why I am praying for. He is admitted on last.
Stay down.
হ্যাঁ গেটফুল
দু সপ্তাহ
Yes, next.
দু সপ্তাহ তো
Doctor.
184
1 day's accommodation is needed on behalf of the state.
grateful 185
Okay.
Next week.
186
But 186 not happening.
187
87 will not have the respondents West Bengal College Service Commission.
188
I am appearing on behalf of the council, Purbo Midnapur Lordship. 188.
189, you are appearing?
Yes.
I am appearing on behalf of
188
the council.
আপনার কত
88.
88
180.
188. You are appearing in 188?
On behalf of the council, Purbo Midnapur.
Yes,
188
The order is page 47.
Which matter?
The son of the petitioner was a primary teacher. He got the job on compassionate ground on the death of his land loser category. Due to the torture by cruelty by wife, he committed suicide, leaving the mother, the present petitioner. But taking as soon as the husband died, initially she was in my house. Subsequently, she left. She tried to get all the retirement benefits, everything, including the job. I raised objections that I am also entitled to being the son of the mother of the son. I am also entitled.
So this is the
But-
mother-in-law and the daughter-in-law.
Yes, mother-in-law.
Mother-in-law and the daughter-in-law.
Yes. Now, my lord, what happened? The writ petition was filed long ago. At that time, nothing was given. Now, my lord,
at the time of hearing, just before them, I'll kindly see the order. On 18, matter was taken up for hearing and directed the authorities to appear. On 19, my lord, order was passed. The writ petition was dismissed on the ground that you have got the money, you have suppressed the same. My lord, page 48, internal page 2, third paragraph. Mr. Soikot Banerjee, learned advocate appearing on behalf of the chairman, DPSC, has submitted petitioner was not entitled to provident fund amount, but he has come with the document to show before this court that the petitioner has received an amount of rupees 33% of the gratuity amount which was paid on February 2023. The whole amount is of rupees such and such by way of 30% such and. This fact was not intimated to this court yesterday when the matter was taken up. It has been stated by Mr. Banerjee that the payment was made on 3rd March 2023, that is after filing of the writ petition. However, in my view, this fact should have been intimated to this court yesterday when I was passing the order of the personal appearance. For suppression of such fact, I now recall that part of my order where I have directed the chairman to pay rupees 5,000, and the said chairman is not required to pay any amount to the PD. It is a proper case. On the contrary, for payment of some amount of money to the chairman by the petitioner, as a petitioner is a helpless lady who has lost her son, I am not passing such order. The other part of my order directing SI of the appellate judge and circle inspector is also recalled. He is also required to be present before this court, not required.
Now, where is the order by which her objection was considered?
That was not done.
The objection, lordship, had been considered by the authority concerned.
Where is that?
The lordship, already he has entitled to get only for gratuity amount.
We want to see the order by which it was considered. If she
There was
has-
no consideration.
See, there are two things. It's a dispute between the daughter-in-law.
Lordship's
It's a dispute between the daughter-in-law and the mother-in-law.
Lordship.
Now, who got the employment?
The lordship, the wife will get the employment. The
Under the-
mother is not entitled to get the employment.
But the
Mother is opposing. On that ground, she is not entitled to get the appointment. How would be possible? Mother is not entitled to get the provident fund. He is already demanding to get the provident fund. That is why order has been passed by this court. The submission has been made on behalf of the council. Mother is not entitled to get the provident fund, but mother is entitled to gratuity amount. He had received 1,25,000. It has been released, and that has been released in her favor. He had received it.
No. Mother was not entitled to the
To get the provident fund.
compassion for appointment.
She is not entitled to get the compassionate appointment. Wife is the sole authority to get the compassionate appointment.
That is in a simple case. Here my son committed suicide due to the
Lordship,
cruelty.
that has not been proved till now.
Under the rules, who is entitled to what is your prayer? What was your grievance? What did you pray for?
Lordship, kindly look into this prayers of the
Page 27.
page 27. Not to make any payment by any of financial service benefit of the
No, this
Mohadev Majhi.
financial
since this
benefits
is to
must
the
follow the
respondent number
service
6.
rules. Financial benefits must follow the service rules.
Yes.
So what are the service rules provided? You will get your share.
Yeah.
The daughter-in-law, they will get her share.
Yes. Yes.
So what is the wrong with this?
But
And during the pendency of the writ petition, this 33% was paid to you. And if
Yes.
if over and above this, any financial benefit is payable to you,
My
that will
lord,
be released to you.
they are saying that I am not entitled, but provident fund amount, my lord, only gratuity has been given.
Yes,
Provident.
you show us the rules to which they are entitled to, what amounts they are entitled to. You must show us. Your mere submission will not do. That on the death of the son, what are the entitlement of the writ petitioners in terms of financial benefits? You file an affidavit disclosing it.
Lordship,
Take it down.
Lordship. Only she is entitled to get the gratuity amount, she is not entitled.
Whatever
to-
is that, she is entitled.
Lordship.
You are representing the
On behalf of the council Purbo Midnapur.
land council representing the district in
Item 189.
Item 189, I am from the petitioner led by Mr. Dibyendu Chatterjee, who is appearing before court number 14, kindly paying for notice.
190.
A very short point. Lordship will take the memo once.
This is the other side.
Mr. Bikash Bhattacharjee was aware in my narrative. Lord,
Very keen.
Who?
Because Ranjan
He was there in the other matter, NTPC. He addressed us.
Our instruction.
He addressed us. He was there.
But,
The first matter at 2 p.m.
but
Don't make him look like so sick.
he actually instruct.
kindly have
Wrong
a
instruction. He was there. We saw him.
kindly have a look at. Milord, special officer's report was directed to be filed on 19th. It was filed by 19, exception to special officer's report. Relates to a unedited.
Will it kindly 1 day accommodation, please, because
He cannot appear alone. Who is the other person appearing? He cannot appear alone. There must be a junior to him.
junior is
Junior is?
not able to attend the court.
He cannot appear single. He cannot appear alone. He's a senior counsel.
Kindly have a look at the order and kindly have a look at page 243. Milord, order is in the memo of appeal. Milord, this memo number, Milord, the appeal number is 1404 of 2023. That is item number 191. That is item number 191. Though exception to the special officer's report has been said to be filed as per direction of the court, but in fact it has not been filed. But the council totally misled this court that exception was filed. Exception will not be accepted for such misleading statement. The respondent Eastern Coalfield Limited has deposited an amount of rupees 6 lakhs with the Register General of the court. I am not accepting the exception to the report as indicated above. I direct disburse of payment of 3 months salary to the petitioners from the date since when it was not paid, the amount within a period of 10 days, the matter would be heard. Further payment for such 3 months salary, it is adjourned salary. So, Milord, it's my mistake. Milord, you affirm, Milord, slip of tongue, Milord. I said it has been filed. It is affirmed. On 19th, served on my learned friend, page 242 at 243, Milord. Kindly have a look at it, Milord. 19th, I have filed. It was a, Milord, normally we mean, Milord.
3 months salary is paid, how you are affected?
Milord, kindly, it's a grant in aid. There was an earlier direction by the division bench, Milord, that this issue will be decided. Milord, kindly have a look at page 243. On the kindly have a look at page 243. It's Milord, canon number ta bolo. Can one. Kindly have a look at that's volume 2.
Volume 1. No, writ petition is pending. No, writ petition is pending.
Writ petition is pending. There was initially no interim order. Then there is interim order, Milord. Time 1, 2, 3, Milord, 3 interim orders have been passed. I'm not on that, Milord. I'm on a very short point before your Lordship. Lordship can decide this issue here since Lordship is hearing, Milord, one of the matters, Milord. Kindly have a look at page 242. Milord, it's a covering letter. If my exception, Milord, goes.
What is your objection to this amount being paid to?
Milord, they are not our employees, grant in aid. I relied upon the NALCO judgment. The division bench said very well, you deposit in court, but this issue has to be heard out. Milord, somewhere down the Milord, kindly have a look at page 242 once, then I show Milord. 242. Milord, it's volume 2, Milord. It starts. Ki bolcho 242 ta 240. Yes. 242, Milord. What else? Milord, 242. 242 pata. Saptoshi Chithi. Milord, kindly look 19th May 2019, Milord, 2023. Milord, this exception to the report, I found Milord on Milord that date itself. I served her a copy also. It's Milord, my Milord, just a slip of tongue. I said it's filed. Normally, Milord, we keep it with ourselves, Milord. Milord, and 251 is the proof, Milord, that I affirmed on that date itself. Kindly had look at the affirmation date, sign of the commissioner, 251. And Milord, so further for deposit further 4.8 crores. And kindly look at the division lakhs, Milord. Kindly look at the order of the division bench, Milord.
Copy is not match. Their copy provide
It
us.
can one.
Can one.
Volume 1.
Volume 1.
There are 2 appeals.
Is one number.
দুটো স্টে আছে
One.
অন্যটা দেখছেন
No.
ওনারটা বার করে দাও না
No.
kindly have a look at
It's not matching.
Milord, kindly have a look at page 233, the division bench's order. Lordship decides this issue. I have no difficulty.
Very confusing situation.
Lordship decides this issue. But Milord, if something is affirmed, served on my learned friend, why my exception will not be taken on record?
Because they are actually failed to produce that date.
I had it with me.
Were you not served with the
Yes, 242. 242.
Were you not served with this, madam? Were you not served with this affidavit, this exception on behalf of this, prior the matter was taken up for consideration?
We actually received that their copy, but they are supposed to be present before the court.
No, that's a different issue. So you were aware of what are the exception is there.
Yes, I received.
But they have not filed it. That's the point.
This is a point.
But this has to be decided. The court has to direct whether this amount is required to be paid or not, only after taking into consideration the exception report.
For 252.
Yes,
Then how the 3 months payment can be directed without taking into consideration the exception report?
they actually failed to produce the document
I had it in my
exception.
hand.
And
The original was
therefore,
not.
No,
you have
no,
not-
original, my lord, was with me, my lord. It was my.
But you have not filed it.
No, my lord, in appellate side, every time, my lord, we affirm and keep it with ourselves, my lord. We give it to the court, my lord.
No, that's a wrong practice.
It's a wrong practice, my
Yes.
lord. My
So
lord,
if
it
you
was
have
my
not
slip
filed
of
it,
tongue.
you have not
It
filed
was, yes. But my lord, they have filed an opposition reply also, page 252.
No, this was filed before the learned single judge.
Yes, he did not say, I'll not take it since you have said it has been filed, but you were affirmed it only. So you misrepresented me. Now, my lord, reply is also filed, 252 by my learned friend. Reply is taken on record. I do not want to, my lord, make any comments. My lord, reply also filed. This is a wrong practice. One should file it with a filing number, but normally. আছে original টা এনেছিস?
Take down. What was your prayer in the writ petition?
here is that I actually challenge
Page
that
81.
closure notice issued by the ECL and school is set up by the ECL itself.
My lord,
And they are
kindly have a look at.
actually
Just listen to us. The subject matter Unless single judge was not interfered with.
No, but Millard, REIT should have been done with deposit. I have done the deposit. Now there is a question, Millard. I'll take exception to the report that the REIT has to be heard out, calling for an independent audit. Where is the question of making further payment, Millard? If Lordship wants an audited Millard, independent Millard, I have taken instruction. We have no difficulty.
For which purpose?
That was Millard. Whether it's a grant in it or not, independent audit would be done. That is Millard, page 238. Lordship takes Millard. Prima facie in view of this court, that's a division bench, 238 Millard, first paragraph, full paragraph. Prima facie in the view of this court, this honorable single bench may invite independent audit of the regular allocation and disbursement of grant in aid. So whether it's a grant in aid or an actual employee, Millard, that has to be decided. Lordship can call for an audit. Officer, order me, Lordship. Lordship, just give me a minute. Kindly, Millard, have a look at page 228. Page 228. Relevant, Millard, is 230, 228. Millard, the last portion at page 238. I said the school was not running. ECL said, special officer says schools are running. There are 19 schools.
19 schools.
Special officer
Surprise visit, Millard, he has to make.
appointed Mr. Pradeep Kumar Ghosh, right advocate, as special officer to make a
received the check
Which check?
that
It was directed to be deposited.
It was
for the
directed
Registry
to be
General.
this registered general, my lord. There was a direction of payment. They have received, my lord, some amount out of that. 4,80,000 they have. There was 480 already disbursed, 120 is remaining. There are further directions for further deposits which are challenged, my lord. 203 and
Yes,
480, Didi bole 480. There was no stay, so they have taken. Someone has.
There's no stay means?
There was no stay by the appeal court on that order.
Which order?
My lord, this particular order.
14 July.
Yes, my lord, the sixth, the direction for my lord release.
14 July was the order passed.
Yes, order passed. So, my lord, 480, my lord, they have already taken. So my exception has to be taken and 120, 1,20,000 is still lying there. So no one has, and my lord, there's a further order passed subsequently deposit further 4.80 lakhs.
because
4.80
teacher
lakhs.
is working in the school.
So, my
they
lord,
are
that,
supposed to be receive the.
that has to be
vacant.
stayed, my lord.
Question is this, if there is a closure and the closure is upheld, then what would happen? If the
School
closure
is
is
running. School
If
is
the closure
running.
is upheld, then what would happen?
School is running by the.
No, I ask you a simple thing. If the closure is upheld, then how how this, on what basis they will receive payment?
School is running means
Now,
the
who is running the school?
teacher is running the school and
The
student-
private managing
because,
committee.
Milord, I
Private
actually,
managing committee. Milord.
what is happening, this
See,
case,
This amount you did not receive prior to 14th of July. From the date of filing of the writ petition till 14th of July, did you receive any amount? No.
no,
So by reason of this 14th July order, this 3 months salary was allowed to be disbursed.
That
That's all.
4.5, 4.8 has been taken. Milord.
Suppose today if it is declared that ECL has no obligation, then who is going to reimburse this amount?
there is, Milord,
No, I ask you a question. That is, suppose today the closure is held to be valid. Because this 6 lakhs, when it was asked to be deposited, there was no, it would have been open for the learned single judge to direct payment of the salaries
because
without keeping this amount in the, with the registrar.
Milord, may I submit one more thing? The ECL start the school, set up the school.
We are not on that, we are on an interim order, madam. We are on a very small interim order. You filed the writ in the year 2016.
16,
From 16, you are not receiving any salary. We have presumed
receiving the salary
receiving the salary
Yes.
till
till,
closure, till closure.
no, closer. After the closer notice issue, thereafter, we actually challenged,
When did you last receive the salary?
received the salary, 2000.
And Milord, one of the writ petitioner has died, but money is taken, Milord. Ishwari Prasad has died, money has been taken, Ishwari Lal.
Since when this,
Last page is 2020.
2022 was the last payment.
Yes,
So 2022 was the last payment.
yes.
Now,
And the teacher is working
Okay,
in
Ishwari
the
Lal does
school last 14 years, 40 years.
And one of the writ petitioner died, Milord, who took the salary, Milord, I really
you are not receiving the salary from November 2022.
Yes.
So that is why ECL was directed to, that is why the ECL was directed to make a clear disclosure of the status of the disbursement of his grant in aid. So long this issue is not decided, because after November 2022, madam, you did not receive any amount. Is a fact recorded in the order. So 6 lakhs they have deposited. Now this disbursement is dependent upon the disclosure with regard to the status of disbursement by ECL. If it is for the school, you are immediately entitled to remuneration. If it is not, so that is why so long the exception report is not considered, how the disbursement could be made. And when this 6 lakhs was directed to be deposited, when?
No, again. It was the order of 2nd of May, Milord, I give the date. 2nd of May. And Milord, one writ petitioner died, Milord.
Second
In
May.
the meantime, who is drawing the
May?
salary?
2nd of May.
2nd of May,
2023.
2023.
So
One writ petitioner died. রাখুন আপনার কাছে পরের ম্যাটারটা বলছি।
earlier, 2019 also, some of
No,
them.
but that is recorded what we say regularly. We go by
Whatever is recorded. Ed, 4.8 million already withdrawn.
very well.
Lordship will record that. They have already withdrawn. 1.2 is remaining. I'm sorry.
Mat 1404, এটা Mat 1404 order.
17, the writ petitioner is already dead, my lord. I have given the death certificate. So who is withdrawing the money and whose favor, no one knows.
কি আছে দেখি অর্ডারটা দেখি
One appeal.
This is, my lord, the continuation.
but
my lord.
if you have a closure then
My lord, I have a closure. They asked for a declaration. The
but if
honorable,
you have a closure then we have to pay compensation to them. You
my
pay
lord, there are
compensation.
we are giving granting aid. Lordships are already held, my lord. No direct employee that has to be established. Whatever form, I may lose finally. But 2016, on this ground, there was no interim order, only affidavits. I can show.
Justice Karnar passed the order that time.
Yes.
So
Kindly have a look at further deposit of 4.8 and reasoning, Miller. This issue has to be decided. In fact, the division bench also said then, Miller, the earlier division bench, this issue has to be thrashed out because he has claimed for the declaration in page 100 that, Miller, there existed the employer-employee relationship and the declaration to such effect. So unless that declaration is there, how can this be done? And I am facing an audit that, Miller, these schools are not in operation.
it is an operation, Miller. They
It
are
is a privately
in the-
managed school by private managed.
They are-
Naturally, Miller, Lordship, on those days, Miller, ECL used to give the land, you build up your school.
So
Now,
ECL
Miller,
the school-
ECL doesn't have, neither they're the part of the managing committee, nor, Miller, they run
Teacher
the
is
school.
not supposed to be collect the student from the anywhere.
And, Miller, these are not fully ECL staffs who are, Miller, running, Miller, going to those schools.
Appointment was made by the
Sorry?
manager.
Managing committee privately managed. Kindly have a look at the order for the deposit of 4.8 lakhs.
On the basis of Coal India agreement and NCW 2, 3 and it is clearly mentioned.
আগেরটা ভালো কথা তো বলে দেবে
Mentioned. And 196. 196. Your lordship was on the virtual mode. On the last day, I mentioned before Justice Kumar. Now, my lord, for this upgradation, 195. Honorable single judge, my lord, we are the government officers. My lord, the person concerned did not lodge any offense with regard to her entitlement. So far as DA is concerned, she got everything, my lord. The honorable single judge directed the Vigilance Commission and the government to lodge FIR against our client, the government officer, and charge sheet to be issued. Yeah, absolutely without jurisdiction.
No, which matter?
In the 195.
196.
196.
197 also.
Was called.
Huh?
197.
No. No.
So without hearing us, we are
I-
not the party to
Justice
proceeding.
Kumar Miller kindly remembers when Justice Shane Miller was, your lordship was kind enough to upgrade this matter. But this, unfortunately, this has not come today. This has come, but not
this for the
after.
writ petitioners.
Miller writ petitioner Miller did not lodge any grievance.
No, this for the writ petitioners.
The writ petition has been served, Lord. Writ petitioner.
I am for the statement in this matter. I am for the statement.
No, your will not have.
No.
The read petitioner.
Writ petitioner
Writ
Miller
petition is
kindly
disposed of. Writ petition.
Around.
This writ petition has been disposed of, my lord, in 2000.
About when the order
Miller,
was
kindly
passed.
grant us, my lord, kindly grant us, because your lordship don't want to take up this matter, my lord, on every Thursday. Now, my lord, in between Thursday to Thursday, the government will lodge FIR against the Awas. Yes, my lord, that is.
Your officer.
No, my officer, the honorable single judge, my lord, because it's had some ramification, my lord. I cannot say much, my lord, but
No,
it has
which
some
order?
ramification.
Which is the other side?
My lord, from the order, I will show your lordship, my lord, the writ petitioner did not lodge it once.
To us. 195.
195.
But why you have not mentioned this matter in the morning? Why you have not mentioned this matter in the morning?
But I thought, my lord, that
Monday
I mentioned.
Monday I mentioned.
Your lordship's court officer say no, my lord, it could not be upgraded. Takes Spain Miller to turn, page 90. 104. These three orders, Miller,
No.
the investigation by the Vigilance Commission is complete and they have supplied the report in the sealed cover, which was not supplied to my client, which is not open today. However, the Vigilance Commission seeks leave to frame the article of charges against the 4 officers in respect of Vigilance Commission is not an employer, my employer. They want to send it to the disciplinary authority for filing the FIR against them. Such leave is granted. For lodging the FIR, the Vigilance Commission will recommend it, for which leave is granted to them by court. Let this matter appear on 17th August 2023, when I believe the article of charges will be prepared and will be sent to the disciplinary authority. This is kindly seize the order.
This matter is going on not.
Matter is,
This matter is going on for some time. You have not challenged these orders.
Millard, 6 December, Millard, page 90, kindly seize, page 90.
You have not challenged this order.
Millard, the interim order does not decide the main issue, the
I
ultimately.
direct the Commissioner of Vigilance.
Millard,
No
kindly
action
seize.
will be taken up.
Millard, kindly.
No. Sorry, no.